Whilst Constitution vests significant powers in the governor, these powers are certainly not unfettered. The Supreme Court of India has previously delivered multiple judgments upholding the tenets of federalism from the lens of the governor's office and powers. The court reiterated that the governor's powers are not absolute and must be exercised in accordance with constitutional principles. The governor, when he withholds assent, should return the bill to the legislature for reconsideration. Indefinite delays effectively frustrate the will of the elected representatives and of the people that they represent. These tensions boil down to constitutional boundaries of how far can the judiciary proceed forward to interpret the constitution to ensure complete justice and end legislative paralysis, and how far the elected union government can wield the governor's office as a weapon to obstruct legislative process in opposition ruled states. In the past few weeks, the cracks in India's federal structure have been exposed by the Supreme Court in its latest ruling in State of Tamil Nadu versus R.N. Ravi, which has further set another precedent in a line of cases limiting gubernatorial powers. Federalism is a system of governance that divides and shares powers between the center and the regional units such as states or provinces. In such an arrangement, each state retains its political identity, although may not have an independent sovereignty. It retains its independence in certain areas whilst also participating in the collective decision making of the union in other areas. In India, few constitutional officers have sparked as much debate and tension as that of the governor, who plays a dual role between being a ceremonial head of the state and being the bridge between the union and the state governments. Whilst Constitution vests significant powers in the governor, these powers are certainly not unfettered, and the recent Supreme Court verdict imposes a 1 month timeline on the governor to undertake certain tasks and a maximum 3-month timeline on certain other tasks. The Supreme Court also imposes a 3-month timeline on the President of India as regards bills that are sent by the governor being reserved for presidential assent. These developments mark a significant step in defining the limitations of the powers contained in Article 201 of the Constitution. The Supreme Court of India has previously delivered multiple judgments upholding the tenets of federalism from the lens of the governor's office and powers. In the case of Shamsher Singh versus State of Punjab, it was held that the governor must generally act on the aid and advice of the Council of Ministers, except in specific areas where the Constitution grants the governor discretionary powers. The floodgates of judicial review over these discretionary powers were further considered in S.R. Bommai versus Union of India, when the Supreme Court held that the imposition of President's rule on certain states is subject to judicial review and cannot be exercised arbitrarily. Similarly, in Rameshwar Prasad versus Union of India, the court reiterated that the governor's powers are not absolute and must be exercised in accordance with constitutional principles. Now, before we delve further, let's look at what exactly are the powers of the governor under the Constitution of India. Article 200 outlines the powers of the governor, particularly when it comes to bills that are passed by state legislatures. When a bill passed by the legislature is placed before the governor, the Constitution provides 3 options: either to grant assent, to withhold assent, or to reserve the bill for the consideration of presidential assent, that is, for the consideration of the President of India. Except in cases of money bills, the governor, when he withholds assent, should return the bill to the legislature for reconsideration. The legislature may or may not consider the amendments proposed by the governor's office and may or may not include them, but if the legislation is passed again as a bill by the legislature and sent back to the governor has no option except to grant his or her assent. Similarly, Article 201 delineates the procedure to be followed when the governor reserves a bill for presidential consideration and presidential assent. The article states that the president may assent to the bill or withhold assent. However, this provision is silent on the timelines that is to be followed either at the hands of the governor regarding assent to bills or by the president regarding a similar exercise. This absence of timeline has historically been a source of tension in the instance where the ruling party in the state is not the ruling party in the center. In such instances, the office of the governor could be misused to impede legislative processes in the states. The Supreme Court's recent decision redefines center-state relations from a critical angle by establishing timelines for both the governor and the president to decide on such matters pertaining to bills presented to them. The rationale behind this decision hinged on the notion that inaction violates the constitutional principle of non-arbitrariness and exercise of power within reasonable contours. By setting timelines, the Supreme Court's verdict empowers states by ensuring a more predictable time frame for legislative promulgations. States can now challenge undue delays if the president or the governor fails to act within the timeline stipulated, that is 1 or 3 months as the case may be. Now this aspect certainly aligns with and gives effect to the recommendations of previous commissions which looked into this aspect, in particular the Sarkaria Commission on Center-State Relations in 1988 and the Punchi Commission in 2010, both of which advocated for time-bound decision-making on reserved bills. Indefinite delays effectively frustrate the will of the elected representatives and of the people that they represent. The timeline specified by the Supreme Court allows laws passed by the legislature to come into effect without undue obstruction, thereby upholding the principles of representative governance. By mandating that any delay beyond 3 months must be reasoned and communicated to the state by the president, the Supreme Court has ensured transparency and accountability in the discharge of presidential functions. Moreover, the Supreme Court stated that if a bill is reserved by the governor on grounds of unconstitutionality, the president ought to seek the opinion of the Supreme Court under Article 143. This decision has also placed the spotlight on another bone of contention between the judiciary and the executive. The Vice President of India, in his recent utterances, was especially critical of the judgment, classifying it as a judicial overreach. The pain point seems to be that under Article 142, the Supreme Court has deemed the grant of assent on certain bills, and this the Vice President describes as the apex court's action being akin to that of a super parliament. These tensions boil down to constitutional boundaries of how far can the judiciary proceed forward to interpret the constitution to ensure complete justice and end legislative paralysis, and how far the elected union government can wield the governor's office as a weapon to obstruct legislative process in opposition ruled states. The debate does not end. Recently, the President of India has issued a presidential reference to the Supreme Court under Article 145, seeking the opinion of the Supreme Court on about 11 questions. And more importantly, one of the questions is whether the exercise of constitutional powers and orders of the President or by the President or of the Governor and by the Governor be substituted in any manner by exercise of power under Article 142 of the Constitution of India. It would be interesting to wait and watch to see what the opinion of the Supreme Court will be on this aspect.